second speaker is Simon Rubenstein on Directors' duties and the development since OneTel. Simon Rubenstein.
Thank you, Michael. Thank you for inviting me to speak, and thank you everyone for coming. Phil's told 3 jokes, which is the appropriate quota for this morning, so I'm off the hook and don't need to tell any at all. Perhaps other than my tie is the joke that I am wearing, being the colour and width that it is. Now, I've been asked to talk on effectively statutory directors' duties, and what I'm going to do is I'm going to cover 3 areas broadly, just very, very briefly, because I don't think you can talk on developments in the area of statutory directors' duties without talking about what are the duties very broadly, who's liable. I'll gloss over some of the issues relating to civil penalty regime. There's a paper that's in the materials, and it's quite a detailed paper, and it talks about my sort of pet love, or my area that I love and I enjoy working in, which is dealing with civil penalty actions, ASIC regulation, that sort of thing. I want to then move on to just talk briefly about the OneTel decision, because I think that's quite an interesting point to effectively focus on, to then look at some of the things that are going on now through the courts, and then to finish on other developments and trends. And it's quite timely, this talk, because last week ASIC released Regulatory Guide 217, which was a guide for directors dealing with insolvent trading, and some advice and recommendations to directors to avoid their duties in respect of insolvent trading. That is, to avoid breaching their duties, I think is the appropriate word to include there. So what are the duties? Very briefly, the Corporations Act sets out a number of duties in statutory form. They are the duty of due care and diligence, and that's where most of this talk is going to focus on. Directors and officers must exercise powers and discharge their duties using the degree of care and diligence that a reasonable person would use if they were a director in that company's circumstances. And there are 2 critical aspects to this statutory duty. The first is that it imports an objective standard, what a reasonable person would do, and it's not subjectively based on that particular officer or director. And secondly, it's subject to the business judgment rule. The business judgment rule is set out at page 2 of the paper, but broadly speaking, it will be a business judgment, and therefore there will be a defence for directors and officers if they make a decision or take an action in respect of a matter, and they do so in good faith for a proper purpose. They do not have a material personal interest in the subject matter of the judgment. They inform themselves about the subject matter of the judgment to the extent that they reasonably believe to be appropriate, and rationally believe that the judgment is in the best interests of the corporation. It's effectively the statutory business judgment rule. The other statutory duties are found in section 181, subsection 1, which is the duty to act in good faith for a proper purpose. And then there are the conflict of interest duties, that is to prevent conflicts of interest, not to properly use position, that is an officer not improperly using their position as an officer, and not to improperly use information of the company, found in section 182 and 183. The other main duty, which is given quite a bit of attention at the moment, and I'll finish on this, is the insolvent trading duty, that is the duty to prevent insolvent trading in 588G. Effectively, directors must take all reasonable steps to prevent a company from incurring a debt if the company is insolvent and the test for insolvency under the Corporations Act is unable to pay its debts as and when they fall due, or becomes insolvent by incurring that debt, and there are reasonable grounds to suspect that the company is insolvent or will become insolvent by incurring that debt. Who's liable? Well, it's not just directors. Directors' duties are a little bit of a misnomer. Of course, it covers directors that are properly appointed. It also covers de facto directors, those that are effectively standing behind the directors and are controlling and managing the affairs of the corporation. those people that the directors are used to acting in accordance with their instructions, but it doesn't cover professional advisors. There's a carve-out for professional advisors, lawyers, accountants, bankers, so on and so forth. And, of course, it also covers officers of corporations. So directors, secretaries are defined as officers. Again, people who participate in the business decisions of the company, people who have capacity to significantly affect the financial standing of the business, and also people who the directors are used to acting in accordance with their instructions or wishes, but again there's the carve out for professional advisors. Officers also include, and the definition of officers also include receivers and managers, administrators and liquidators. Employees used to previously be under or be included in the definition of officers. That was removed by some statutory amendment some time ago, but they still can come broadly within the definition of an officer if it's a senior level employee, senior manager, and that person makes decisions about the business or the financial standing of the company. Of course, employees are expressly included into Section 182 and 183, and that's led to some interesting and novel applications to the court against employees in the context of theft of company information, corporate information, breach of confidentiality, restraint of trade clauses in employment contracts and things like that, where you find now in pleadings allegations that employees have breached the statutory duties, Section 182 and 183, by improperly using information in the context of breaching a restraint of trade or breaching a confidentiality provision in a contract of employment. Very, very briefly, civil penalty regimes are a statutory hybrid. They sit between civil liability and criminal liability, and they effectively operate similarly to a civil action. They start through a civil penalty proceedings, which is issued through a originating process, affidavit material in support, sometimes supported by a statement of claim. The civil rules of evidence and the standard of proof applies to civil penalty proceedings. Those subject to civil penalty proceedings can claim privilege against self-incrimination, and that claim or the reliance upon privilege against self-incrimination manifests itself in very interesting ways, so that a number of cases, really starting back or emanating back to the water wheel case, many years ago, Justice Mandy in that case determined that John Elliott and Mr Plyman, some of the other defendants in that case, didn't have to put on defences. When they did have to file defences, they were very, very narrow defences. They didn't have to set out a full defence. Affidavit material and statements and things like that don't need to be provided, usually until the prosecution, that is ASIC, has made its case. So ASIC has to effectively prosecute its case, lay out its evidence, run its case, and then the defence will have an opportunity to put on material. And it also has played itself out in things like discovery, where defendants are often not required to make discovery in circumstances where they rely upon privilege against self-incrimination. And what can occur in a civil penalty action? Well, the court can make a declaration of contravention and can then declare that the defendant pay a pecuniary penalty order of up to $200,000, and then can also order that the defendant, if there is a declaration of contravention, make compensation or pay compensation, which effectively is a damage suffered by the corporation. It can include a disgorging of profits if any particular profits have been made as a result of the breach of the duty. It can only be claimed by the company, so it's not a relief that broadly can be claimed by other parties, including shareholders or other parties, third parties that might be affected by the director's conduct. And that really fits back to the older traditional view that when a director breaches a director's duty, it's the company that is the party that suffered the loss. It's the true defendant, and it effectively is the it's the true plaintiff, and it quite properly has the remedy and not anyone else, not shareholders, for example. And it also operates, I should go back to that last one, it operates as a standalone order in civil proceedings. So if you're bringing a civil claim for compensation, you can also link into section 1317H of the Corporations Act for your relief, for your remedy, effectively a compensation order rather than the traditional damages claim for breach of directors' duties. And what also often occurs in a civil penalty claim is that disqualification orders are made against the directors, and the James Hardie litigation where the decision was handed down, I think it was last year, is a very interesting one for the disqualification orders, because in that case both executive and non-executive directors were disqualified from management for many years in a lot of instances, and it really that's where often the sting in the tail is, to end the corporate careers of high-level directors, particularly in public companies. There is a defence to these types of civil penalty claims, and that is a defence of honest contravention found in section 1317, capital S, subsection 2. And some examples, we've had some very high-profile examples of civil penalty cases. They are often make the papers, and they are often interesting reading. We've had the Adler and the Williams litigation that arose out of the collapse of HIH, James Hardie Industries, of course. At the moment in Victoria, we've got the AWB proceedings, and I note there was an article in the paper the other day that Justice Robson has cleared the way for that proceeding to continue in the Supreme Court now. There were issues about whether it ought to be stayed because of potential criminal prosecution. There were West Point proceedings brought by ASIC against a number of directors, and of course there are a number of other cases which I'm going to move on to as well, including Centro, and the OneTel case, which was possibly one of ASIC's biggest failures, and brought considerable cost and took considerable time, and ended up being effectively, at the end of the day, an unmitigated disaster for the securities regulator. It really seems like such a long time ago now that we were extolling the virtues of OneTel, and we were fascinated with the dot-com companies and the new and emerging telcos in the late 1990s. The history of OneTel and the background to the establishment of the company is set out at page 8 of the paper. I'm not going to go into it in any great detail, other than to say that you may recall it was started by Jody Rich and Brad Keeling in the 1990s. It was supported famously by the young Packer and Murdoch scions, the children's, rather than the parents, it was the children who took up the cudgels to support the company. And effectively it was an unmitigated disaster in that regard, and probably resulted in the parents not letting their children out of control, out of the kitchen for some time after that. So it was listed on the ASX in November 1997 at a share price of just over $2. It peaked on the ASX in February 1999 at about $12.60, so it really had a meteoric rise in that short period of time. But when the dot-com bubble burst in the late 90s, early 2000s, it really impacted upon the prospects of OneTel, because OneTel had linked itself so much to emerging technologies and the internet and mobile telephony and all of those sorts of things as well. It was significantly impacted. By December 2000, the share price had effectively tanked down to 46 cents, and that led to effectively the period we're looking at, which was early 2001. OneTel was having grave difficulties paying its creditors. As a result of the cash flow problems with the business, in February 2001, the directors organised a transfer of about $26 million from the UK business arm to Australia to help with cash flow. At the same time, in February and April 2001, it released to the market, or the company released to the market, a number of reasonably favourable statements which really pointed to the potential profitability or the future profitability of the company. On the 27th of February, OneTel announced to the market that it was, quote, focused and on track to becoming cash positive as forecast by June 2001. On the 4th of April 2001, a further announcement was made to the market that the company was tracking very well against forecasts that were initially made by management in August 2000. The company is fulfilling the promises made to our shareholders to turn the business cash positive and have a cash balance of $75 million by 30th of June 2001. It transpired that that wasn't quite the rosy picture that was, or the truth was not quite the rosy picture that was being painted. The directors determined in April 2001 that a further rights issue for $132 million was required, and that was going to need, effectively, provide a capital injection to assist with the continuation of the business, effectively provide for cash flow in the short term. In May 2001, the auditors were called in for a special investigation and report and found that the financial position was in fact much worse than reported, and that the rights issue, the $132 million, was not going to effectively stop the rot and solve the cash flow problems. So in that context, administrators were, Jody Rich and Brad Keeling fell on their swords. They resigned as directors. The Packers and the Murdochs called in administrators. It was placed into administration in May, and that subsequently effectively resulted in the administrator, the creditors resolving that the administrator ought to become the liquidator, which is what occurred. In December 2001, ASIC, and ASIC had been investigating for some time, commenced civil penalty proceedings. Broadly, it commenced proceedings against 4 people: Jody Rich, Brad Keeling, Silverman, who was the finance director, and John Greaves, who was the chairman. I've set out the history of the interlocutory processes. In short compass, Keeling and Greaves ended up settling with ASIC. Keeling didn't settle with ASIC until sort of late on in the piece, and admitted wrongdoing, admitted breach, and often in these cases, as transpires, he admits breach, the matter runs its course in court, the other directors are found to be not liable, and he's put his hand up first, and he's effectively taken the rap where the others escape liability. The same thing happened with Greaves, but that happened in interesting circumstances. What occurred was he brought a strikeout application against ASIC's statement of claim, pleading that the way in which ASIC has framed its case against him as chairman was too broad. That is, he didn't have, as chair, a special higher level of duty of care and diligence that otherwise would exist for executive and non-executive directors. That issue was determined against him. That is, Justice Austin found, yes, ASIC, it was arguable for ASIC to claim that as chair he had a higher level of duties, that the responsibilities of chair were that was slightly above and broader than the duty of care that applies to other directors. In light of that, and shortly after that, he settled with ASIC and again admitted liability and copped quite a significant fine and part of the compensation claim. But Rich and Silverman didn't, and they continued the fight. The claims broadly that ASIC made were that Rich, Keeling and Silverman had withheld financial information from the board. So effectively it was a claim that the executive directors were holding information from the non-executive directors on the board. Also that the information that had been released to the markets, those announcements that I had referred to earlier, were false and misleading. And because of that, there was a breach of Section 180, subsection 1, the duty of care, to act with due care and diligence in discharging their powers. And the role that ASIC had to, I mean, it was the proceeding evolved in an interesting way. Effectively, ASIC had to prove the entire financial position of OneTel in a period from about December 2000 through to April, May 2001, and it had to effectively reconstruct and recreate the entirety of the financial state of the business. The defence took the view that it just needed to sit back and say ASIC's construction and reconstruction, ASIC's interpretation of the finances was wrong. So what did ASIC try to set out to do? Well, it sought to say that OneTel required significant cash, and I've set out the types of cash that it was required, that it said was required at page 12 of the paper. It had to prove that OneTel required $270 million by the 28th of February 2001, another $287 million by the 31st of March 2001, another $309 million by the 30th of April 2001, and that was all based on debtors, creditors and the EBITDA position of the business. So effectively it was trying to show that in order to make or satisfy the types of forecasting and statements to the market, this is what was required, and that it wasn't satisfied on the performance of the company. The directors also provided what were called flash reports to the board, and ASIC was required to effectively show that the flash reports were false, and that there was no proper finance director at all, that Silverman was not properly qualified to perform that role, and the announcements to the market were false. The position that was taken by Rich and Silverman was that, firstly, it just simply says prove to ASIC, prove your case. We challenge ASIC to prove, or to prove on the balance of probabilities the case that it's trying to prove in relation to the financial performance. They didn't lead expert accounting evidence. It was a very interesting tactic. They didn't try to do what ASIC was trying to do, that is to try and prove the counter proposition that the financial position was as was represented. They simply took the position, well, we don't accept what you say about the financial position, and we hold you to the burden of proof, trying to prove otherwise. And they said that the flash reports were forecasts only. Now, effectively, the position that was taken by the defendants was, well, and this is reflected in Justice Alston's decision, if ASIC could prove those things that it was claiming in relation to financial performance, the defendants effectively accepted that that would constitute a breach of the duties. And there was an interesting argument about whether the doctrine of res ipsa loquitur applies to breach of directors' duties, to which Justice Alston said, yes, it does. A very unusual concept, I must say, for a commercial lawyer, for me trying to take into account sort of tortious concepts within a commercial context, but it does apply. And the only real issue that the directors took was that they tried, in terms of the legalities of the duties, the construction of the duties, was that in relation to determining whether or not the responsibilities within the corporation, how that should be framed, what was the benchmark against which you tested the factual position, Rich and Silverman argued that what you do in that regard to look at what the responsibilities of the directors should be is you frame it against, or you judge it against, the Constitution and any resolutions made by the board. So you look at it very broadly. If the Constitution says directors should attend directors' meetings, if they have done that, then you've satisfied the obligation to act with due care and diligence. If a resolution is passed, for example, that a certain document needs to be executed in a certain way, you've satisfied that obligation under the resolution of the company, then you've satisfied the duty. Now, on that issue, Austin said no. Austin said that's not enough, and that's not right. The reference to the same responsibilities within the corporation in section 181B, it's not limited to specific tasks that are delegated to that particular director through formal means of the company constitution and resolutions. It has a much wider meaning, and you've got to look at the ways in which work was in fact distributed to those directors within that particular company, and the expectations that those arrangements had for that particular director, how they were specifically specifically what their specific roles and responsibilities were within that particular company. So in relation to that endeavour to narrow the Section 180 in that way, the court said otherwise. But what the court did say was that ASIC hadn't proven its case. It had set itself effectively a very wide ambit of trying to reconstruct the company affairs, and it hadn't discharged its onus to do so. The countering propositions and arguments that were put by Rich and Silverman in evidence was accepted. They weren't found to be bad witnesses or witnesses of poor credit, and the judge believed their evidence in relation to what they were endeavouring to do in terms of the financial position of the company. There were plausible alternative explanations than those put by ASIC, and the judge found that they were accepted, and that ASIC had also sought to go beyond its pleadings in conducting its case, and ASIC was heavily criticised by the court in doing that. In terms of the findings in relation to the flash reports, they were again accepted by the court that it was just forecasting, and ASIC had misinterpreted the effect of those particular documents. So it really was an unmitigated disaster for ASIC. It had taken and run a very broad case. It had effectively tried to prove the entire financial position of the company was not what it was, instead of targeting a specific announcement or a specific statement or a specific report or set of financial figures. And I think that lesson has been learned in other proceedings, which we'll turn to very quickly. So what's the lessons? Well, the court does summarise, Justice Austin summarises beautifully this duty. So if you're looking for a really nice quick cheat sheet or shortcut to what the duty is about and how it operates, have a look at his summary of the law. I've referred to the responsibility within the corporations not narrowly confined. What His Honour says in relation to Section 180 is that effectively it's a minimum standard. It incorporates a minimum standard of diligence. And what it is this: it's a minimum standard for every director or officer, including non-executive directors and officers, to become familiar with the fundamentals of the business, the business of the company, keep informed about the company's activities, monitor generally the company's affairs, maintain familiarity with the financial status of the company by appropriate means, including, in the case of a director, reviewing the company's financial statements and board papers, and making further inquiries into matters revealed by those documents where it's appropriate to do so. No longer can a director stand behind a statement, well, I'm not financially literate, I'm here to perform other services for the board. I'm not an expert in effectively financial figures and accounts, so therefore I don't read board papers and I don't read the balance sheets and I don't read P&Ls and I don't read cash flow reports and things like that to consider what the financial position of the company is. That's a job that is for other directors who have got special expertise. That's no longer going to be good enough. And in particular, in relation to the issue of financial responsibility, it's a standard of competence in reading and understanding financial material which is not dependent on that director's subjective inexperience or lack of skill. It follows that they can't escape, directors and officers cannot escape liability on the basis that they did not read the financial material that is made available to them for the purposes of their office. And at least to that extent, the duty of care and diligence imports an objective standard of skill irrespective of their own skills and subjective experience. I've talked about res ipsa loquitur applying. His Honour also considers very briefly the business judgment rule, and in short, what he says is that considerations of the business judgment rule actually come into account when you're actually considering whether or not there's been a breach of the duty itself. So you don't just look at the issues that are raised under the business judgment rule as a separate defence, but they're also important considerations when you weigh up all of the mix in determining whether or not there's been a breach. That said, there is a separate defence still, and when considering which of the parties has to prove that defence, His Honour thinks that it's the defendant that has to prove the defence. There was quite a bit of argument about whether or not it was ASIC that had to prove it or the defendant. His Honour says, I think it's the defendant, but the law's unsettled on that and ultimately it needs to be settled by a higher authority. Now, very briefly, there are a number of other cases making their way through the courts at the moment. There is the Centro case down here in the Federal Court in Victoria. ASIC, in a way, has learnt its lesson. It's a much narrower case. You may recall in the Centro Properties Group case, it relates to a specific period of time. In September 2007, Centro effectively announced to the market in its annual statement and its annual report that its books had a provision for approximately $1 billion worth of debt. Within a period of months, and by February 2008, it had revised that figure to about $3.1 billion, a very, very significant revision. And ASIC's case is effectively that the 2007 reports that were released in September 2007 were inadequate, didn't comply with financial standards, accounting standards, and that didn't provide a true and fair view of the entity's financial position as at that time in September, and that was known or ought to have been known to the board. So the revisions really ought to have been taken into account, and there was information there that was known at the earlier period of time. We don't know what the position is. When I last checked, I don't know that the directors had yet filed defences. That might have changed now over the last few months. But again, no doubt they will rely upon privilege against self-incrimination and file very, very narrow defences that don't disclose an awful lot of information. Ultimately, that case, when it does make its way through the courts, it will address very important issues about what level of knowledge and what skill a director must have as an objective minimum to perform their functions. It's going to really follow on from quite nicely what Justice Austin was talking about in the one-tell decision. This time, ASIC has really narrowed its focus in relation to those specific September accounts. The James Hardie appeal is, I think it's been heard and we're waiting on a decision. Again, it's another case in which there's a much narrower focus on whether or not there was particular provisions and whether or not a fund that was established to pay out asbestosis cases was adequately funded, and the word that was used by the board was fully funded, whether or not it was fully funded at a time when the board was making announcements to the market that the fund was fully funded, and whether or not the board ought to have known that on the basis of material that it had, including actuarial reports, it wasn't appropriately funded, it wasn't properly provisioned to cover asbestosis claims. Of course, as we know, in New South Wales Supreme Court found the case proved against the directors and imposed very significant bans, but that's on appeal now. And it's very interesting to note, in the media recently there have been significant queries raised about the conduct of the Babcock and Brown directors, and the former chair of Babcock and Brown, in fact, in her words, was herself in liquidators' examinations last week, said that the directors had received briefings on insolvent trading, but there was real questions about whether or not the directors understood what their obligations were, and the directors received those briefings because overseas directors may not have been clear or sure about what their obligations were as directors of Babcock and Brown. That was from the Fin review 2 days ago. So it'll be interesting to see whether or not ASIC pursues that and issues proceedings. There are liquidator examinations going on at the moment in the matter of Bill Express. another large collapse in Victoria a couple of years ago, and there are similar issues that might well arise if ASIC issues proceedings there. The last thing I want to finish on is effectively this RG 217. So what we do know is that ASIC's very concerned in the current climate about increased number of corporate insolvencies, and what it's done is it's focused particularly on the director's duty to prevent insolvent trading, and it's released Regulatory Guide 217, which is called Duty to Prevent Insolvent Trading, and it's a guide for directors. In short, what 217 does, it sets out 4 broad principles, ASIC calls them the key principles, that directors must follow to meet their obligations to prevent insolvent trading. And they are, and a lot of this really is common sense, but following from the Justice Austin decision and now in view of RG 217, it's really set out, it's clearly identified. Firstly, they've got to keep themselves informed about the company's financial position and affairs. That covers executive directors, non-executive directors, all level of directorships. Regularly assess the company's solvency and investigate financial difficulties immediately. And that's particularly germane if they are put on notice of a particular issue that might arise from board papers or management accounts. Obtain appropriate professional advice to help address the company's financial difficulties when necessary, and consider and act in a timely manner on advice. Now, all of those 4 are amplified in the regulatory guide, and ASIC give examples of what they mean by those 4 concepts. Effectively, it means consideration of P&Ls and cash flows and so on and so forth, understanding how to read balance sheets, obtaining appropriate advice from external accountants and bookkeepers, and so on and so forth. Finally, ASIC also sets out some of the factors that it will consider in deciding whether or not to take enforcement action. So these are, I suppose, some of the discretionary factors that might weigh into the question of whether ASIC will prosecute. These are, or include, what compliance plans, accounting procedures, accounting processes does a company have internally? What systems do they use? What systems are in place that directors can actually interrogate those systems? What information is provided by those systems to the directors? Are they appropriate and adequate systems? What material does the director actually consider and review? P&Ls, balance sheets, cash flows, those sorts of things. Absences of directors and reasons why. Absence for illness, absence for overseas travel. What are some of the reasons behind why directors are not available? Is there appropriate mechanisms in place for directors to be provided with information in their absence? Do they link in through telephone conferencing facilities and things like that to board meetings when they are overseas, for example? Reliance on third parties is a big factor. ASIC will look at reliance on third parties, who they are, accountants, bookkeepers, auditors, lawyers, and so on and so forth, where the legal advice is obtained. And also the significance and the importance of board minutes, and good board minuting and keeping good minutes is also referred to by ASIC. And just to finish on this note, I often give a talk on directors' duties, and I sometimes give that talk with Jim Peters. And Jim is very, very quick to point out that any way you look at it, some of the best advice that you can give as a lawyer advising your clients who might be directors and who hold positions on boards, or even in small to medium enterprises, is it's all about the record keeping. It's all about how well you keep board minutes, you maintain records of the management accounts and things like that. And that works both ways. It works as a defence to prosecution, and it also works if you are bringing claims to produce those minutes and things like that, to say, well, here are the minutes that we've kept. These identify all of these issues, and for some reason there's been some other breach or some other issue raised that effectively makes out the case. So it's all about the appropriateness, the correctness of good minute keeping, record keeping, notes, diaries kept by directors about things that took place, when they took place. Great backup, forensic backup in court cases. Really, that's about it. Thank you very much and enjoy the rest of your day.